Well, good morning, folks, and thank you for joining our CPD seminar this morning titled The Litigator and Mental Health. The title of this seminar is borrowed from a paper authored by our speaker today, which I would certainly commend to you. A link was provided in the notice that was circulated, and I'll also be posting it in the chat window here in Zoom so that you'll be able to access that. This is the latest in a series of seminars focusing on mental health in the profession, which has been an area of particular focus for us here at the Law Society for at least 5 years now. Today's speaker will certainly bring an interesting viewpoint to bear on the issue. And before I introduce him, I just want to address a couple of brief housekeeping items. Obviously, this is structured a little bit differently than a typical CPD seminar where the attendees are mere names on a screen. We're hoping that you can all turn your cameras on for the duration of the seminar. This approach was a conscious decision made in collaboration with our speaker as we endeavor to assist the profession to better connect on this particular issue. Now, that being said, things can quickly descend into chaos with this many people online, so we'll just go through a simple Zoom etiquette. Please ensure that your microphones are muted for the duration of the presentation. Following his remarks, our speaker will welcome questions or comments from the audience. I'd ask that you please use the raise hand function, which you can find by clicking the reactions button on the Zoom window screen, and wait until I call on you before asking your question, or you can also throw your question in the chat window and we can get it there. So with that out of the way, and cognizant of our limited time this morning, I'm just going to give a short introduction and then I'll hand it over to our guest of honor. Our speaker today received his Bachelor of Arts from McGill University in 1970 and a Master of Arts from the University of Toronto in 1971. Studied law at the University of Toronto Faculty of Law, where he received his LLB in 1974 and was awarded the gold medal. He was called to the Ontario Bar in 1976 and entered practice where he specialized in civil litigation. He was appointed to the Ontario Superior Court of Justice on December 13th, 2007, being elevated to the Court of Appeal for Ontario on April 25th, 2013, where he was subsequently appointed as Chief Justice of Appeal for Ontario, the Chief Justice of Ontario and President of the Court of Appeal for Ontario on June 13th, 2014, a position he held until his recent retirement at the end of August in 2022. Ladies and gentlemen, the Honorable George Straffy.
Thank you very much, Christian. I hope everyone can hear me. It's a great pleasure to be with you, even if it is remotely. I can see all of you on my screen, and I look forward to our conversation this morning. As Christian said, I retired just 2 weeks ago. I promised myself and my spouse that I would refrain from at least employed work for a considerable period of time, but I've remained committed to speaking to groups like you on issues of public health, of mental health in the profession. As Christian said, your province has been a leader in education for lawyers in this area, and we're indebted to you for the work that you as a Law Society have done and you as colleagues have done to advance this issue. You have my paper on the litigator and mental health, and I'm not going to repeat what I said there. What I would like to do is talk to you a little bit about what the profession can do, our profession can do, and what individual lawyers can do to support the mental health of our colleagues, our friends, our family members who are affected by mental health issues. And frankly, this discussion is about all of us as lawyers. I want to begin with a disclaimer. I'm not an expert in mental health, but over the past several years, I've spoken to many professionals who are experts and to many more lawyers law students, paralegals, and staff who are personally affected by mental illness. And I think I also know, as a lawyer for over 30 years, a judge for 15 years, I think I know a little bit about the stresses and anxieties and challenges that are generated by the practice of law, and a little bit about how stress, depression, and burnout are affecting our profession. I also want to acknowledge that the issue of mental health in our profession is a multifaceted issue. There's no simple remedy. But I have recognized, and your presence here today is testament to it, that there is growing concern about the issue. And I think the more we bring it out into the open, the more we talk about it, the more we share personal stories, the more likely it is that we'll be able to remove the stigma that attaches to mental illness in our society and in our profession. And if we're able to do that, I think we'll be more successful in bringing about real change and real help to those who need assistance. So I hope you'll let me begin by saying a few words about my particular journey in relation to this issue. About a year and a half ago, the treasurer, the head of our law society in Ontario, invited me to make some welcoming remarks on a symposium that was being held here in Toronto on the subject of mental health in the profession. In my capacity as Chief Justice, I get lots of invitations like that. It's sort of, you've seen it before, I'm sure. It's like a ribbon cutting at the beginning of a program. I say a few words of welcome, I congratulate the organizers, and move on. This time, I told the treasurer I'd like to think about it, because I frankly had reservations about doing it, not because of the opportunity itself, but because I honestly felt that I could not in good conscience sit and listen to members of the profession speak about their own mental health experiences without revealing the experience of my own family in relation to mental health. I concluded that I simply could not remain silent, and I said to the treasurer I would be happy to speak, but I was going to need more than 10 minutes in order to do it. She said I could have as long as I want, and I accepted the invitation. That led to a paper that is available if you are interested in it on the Court of Appeal for Ontario website. It's the court's website. There's a section that says about the court. There's another section that says speeches and publications. And there is my paper entitled Reflections on Mental Health. And that paper was about my mother's experience for essentially all of her adult life with what is now called bipolar illness, or bipolar manifestations. It was then, and what I was told as an 11-year-old boy, was that my mother had a nervous breakdown and that she was being treated for something called manic depression. I have to tell you, and as I say in the paper, those were scary words. What's a nervous breakdown? What's manic depression? God didn't get any better when I was told she was undergoing shock treatment, now referred to in slightly less alarming terms as electroconvulsive therapy, and in fact, a very effective, in some cases, technique. I have to tell you, it was a cathartic experience writing about my mother's challenges, but I also found and considered it a tribute to my mother, to her experience, and a tribute really to her faith in herself and her love for her family. I did it, and at least in large measure, to encourage people to speak about their own experiences, and if they had concerns, either personally or in their families, with mental health, to encourage others to seek assistance for treatment. I can tell you that paper was well received. I received numerous calls, emails, and letters from members of the bar who were either dealing personally with mental health challenges or who had family members, friends, or colleagues who were doing so. A year later, I wanted to continue the journey, and I wrote my paper entitled The Litigator in Mental Health, which, as I say, is available to you. And as Christian pointed out, it's also on the website. And there I suggested that the myth of the so-called gladiator litigator needed to be dismantled, and as both unrealistic and ultimately harmful. I called for a top-down change in the legal profession to the approach of the legal profession to mental illness. The paper focused on the stress of litigation practice, the great highs and lows, the zero-sum nature of litigation, the high stakes, the conflicts, the deadlines. But I know from talking to colleagues like you that the same stresses apply in all fields of practice, whether you're practicing real estate, commercial law, family law, tax, general practice. Those stresses are all there. Let's face it, law is a stressful career. It generates stress, anxiety, depression, sometimes episodic, sometimes more general. I spoke about the harmful myths and ideals that attach to the role of litigators. And just to quote briefly, I said, the stereotypical barrister is held in high esteem, a fearless gladiator wielding a razor-sharp intellectual broadsword, always in control of their emotions, erudite, articulate, powering through long hours of work with pride and not breaking a sweat under pressure, sometimes wounded but never defeated, suffering in silence, quietly bandaging their own wounds, ready to fight another day, able to play hard as well as work hard. We now know, we all know, or we should know, that this myth creates stresses on young lawyers faced with trying to live up to an unrealistic ideal. And I fear that myth also stifles discussion about mental illness and further serves to stigmatize those who are affected by it. I urge more senior members of the profession to take a leadership role, for those responsible in the management of law firms to take mental health seriously and to lead by example. But it doesn't end or begin or end with the leaders of our profession. Mental health, like physical health, applies to all of us. And perhaps I would say, after these 2.5 extremely challenging years that we've all been through, maybe we need to ask all ourselves, no matter what the temperature of our own mental health, do I need to make some changes in my life, my work life, my home life, for the good of my own mental health? Or is there a colleague or a friend or a family member who might need my help in order to do so? So with that background on my own journey, let me turn to some issues of mental health in our society, in our profession. I'm not going to dwell on them because I know from the educational programs that you've heard, you're well aware of them. But I think the starting point is a recognition of the extent to which mental illness, most notably depression and anxiety, are present in our society. And the legal profession is not free from that, and it has the same issues. The reasons are complex, but the scope of the issue is broad. You know the statistics. The Mental Health Commission of Canada reports that 1 in 5 working Canadians has some form of mental illness. It's on a range, of course, it's a spectrum, but 1 in 5 Canadians has some form of mental illness. And by the time they reach age 40, 1 in 2 Canadians will have experienced some form of mental illness. By far the most common of those is depression, which affects almost 10% of Canadians at any given time. But when it comes to the profession, our profession, the numbers are even more stark. Lawyers, it is said, are affected by depression at a rate of 3 times that affecting the general population, and lawyers have the highest rate of depression of all the professions. Burnout is a serious issue in our profession. Large number of lawyers have been and are leaving the profession, not because they haven't given it their best shot, but because they have given it their best shot and aren't getting anything in return. Alcohol and drug abuse are serious issues in our profession. A study in 2020 by the Law Society of British Columbia documented the fact that the legal profession experiences substance abuse disorders at a rate that is much greater than the general population. I think my own anecdotal experience and yours would confirm that. Certainly it's the case in Ontario. Law societies like yours have been recognizing that it's a serious issue. In 2017, the American Bar Association and other associations in the United States established a national task force on lawyer well-being, and some other law societies have done the same, including the Law Society of British Columbia and our law association. So what is it about our profession that produces these high levels of mental health disorders? The causes are complex, and so are the answers. I suspect, however, that we all know some of the answers. Let's state with the obvious one. Let's just take a look at ourselves in the mirror. I'm doing that. I have done that. People who go to law school and want to become lawyers tend to be highly motivated and high achievers. I think if you look at your classmates through law school and in the profession, you can recognize the type. I think probably at least quarters of us were that type in law school. We tend to be what the psychologists call, or some psychologists call, type A personalities. Some of the characteristics are self-controlled, perfectionists, ambitious, competitive, impatient, prone to self-criticism. Bluntly, we're hard on ourselves and we're hard on others. The reference to impatient struck me. If you'd ever seen me in an airport, and my family sees me in an airport occasionally, you'd know that impatience is my middle name, and I know it applies to lots of us. And I know when I look at myself honestly and candid, I know that I'm ambitious. You don't become Chief Justice or a judge for that matter without being a little ambitious. I know I tend to perfectionism, and I know I'm what my family generously calls a control freak. I like to be in charge of myself and my environment. Some professionals say that classifying people as type A and type B is neither accurate nor helpful. They tell us that so-called personality traits are really reactions to the nature of our work and the structure and culture of our jobs. The legal job obviously places high demands to get work done on time and in a highly accurate way. I think there's another side of it, our profession. The nature of our work is such that we look for problems, we look for flaws, we look for mistakes. We tend to do that. It goes with the job. We do tend to be tough on others, and the people we work with and the people we work against. And we're tough on ourselves. Our jobs involve conflict between our clients and others, in which we sometimes intentionally, sometimes inadvertently take on the role of protagonists. Whether it's in courtroom litigation in the conflict in the boardroom, or conflict in a real estate deal, we are frequently required to advance a position that puts ourselves and our client in conflict with the opposing party, to attack the opposing party's logic, to stand up to their demands, to undermine them. And it's hard not to take them personally. And all this conflict, quite naturally, creates anxiety and stress, which eventually, if not treated, can either exacerbate an existing mental health disorder or can exacerbate it. And it makes us prone to other illnesses, such as hypertension, heart disease. That can lead, and the pandemic has made it only worse, to a sense of isolation and aloneness. I also wonder, and I'm not going to dwell on it, but I wonder whether our billing model, the way we charge for our services, tends to lead to excessive work hours, exacerbates our tendency to become workaholics, and increases our stress and anxiety generated by our work environment. Maybe it's time to reassess the hourly rate billing model that so much drives the way we work and the way we're compensated, and which may perhaps be ultimately unproductive. I don't know my audience well enough to know how many of you work in large firms and how many work on your own. I do know from my own experience in large firms and talking to junior lawyers in this province that the hourly rate model is driving them to work what I would frankly call crazy hours, and they're driven to up their billings or up their hours so the firm can up their billings. And there's no question that it contributes to overworking. The paradox is, though, that there's a lot of research, it's not new, that suggests that productivity really falls sharply after people work about 50 hours a week. I'm not suggesting that should be a model for billing. I think it should be much less, but we all know from our own experience that productivity drops off the more we work. And to make matters work, the longer hours we work, the less we are able to look at the big picture, and the more we get down in the weeds with our work. We all know that overwork generates impaired sleep, depression. It's associated with alcohol abuse and other diseases. I'm not saying that we can't work the occasional crazy week, or that sometimes we have to work hard several weeks in a row. I did it as a litigator. I had trials that lasted 3 or 4 weeks, but and we've probably all done it. But I think people are able to work those hours if they're either resolving a real crisis or they are able to take a proper break at the end of it all. That's different from chronic overwork. And I have a distinct memory of a senior lawyer saying to me, how are you going to, if you treat every weekend as part of your work week, how are you going to deal with a real emergency? There's some other research, and I won't get into it, but it also indicates that working more than 5 or 6 days a week actually reduces overall output, productive output. In other words, and we all know this, everyone needs at least a day, and preferably 2, to recharge our batteries and to heal ourselves. Common sense tells us that. The ironic thing is that far from reducing the work week, technology, just like this, is actually enabling us to work longer hours and in some ways encouraging it. Most employees, and I suspect you're, as sole practitioners or lawyers in firms, realize this. The internet, email, and cell phones are actually expanding our working week. We also know that technology is cutting into our sleep time, and that sleep time is a killer when it comes to productivity. Lack of sleep leads to mistake and errors in judgment. Bluntly, people who don't get enough sleep make mistakes. You all know what the impact of the pandemic has been. In one recent survey, almost 50% of the population said that the pandemic had a negative impact on their mental health and stress levels. Other survey done in the United States showed that prescription levels for depressant drugs and anti-anxiety drugs was up as much as 10% in the general population, and by more than 15%, for those of you with young people at home, by more than 15% in the teenage population. My own experience as Chief Justice, responsible for a staff of 30 judges, a court of 30 judges, and a staff of 80 people, was that the pandemic was a time of significant stress and anxiety for the people I worked with. In the first place, of course, everyone was worried about getting COVID and about their parents and children getting it. Parents were trying to figure out how to juggle their jobs with childcare responsibilities when schools and daycares were closed. And in some cases, they were worried about elder care. In many cases, people like me and my colleagues were trying to cope with new and unfamiliar technology. And in the case of the courts, we were working remotely and largely digitally, eliminating paper and creating new rules that caused new challenges and new procedures. We upended our procedures that had been in place for years. The ground was shifting under our feet daily. I know how stressful it was for my own children, adult children, who were coping with challenges while 2 spouses worked at home and daycares and so on were shut. Ironically, and I'd be interested to know your experience. Some people said that working at home was actually less stressful than working at the office. Some lawyers have told me they found it much less stressful to appear in remote court than to appear physically in a courtroom. Many lawyers and some judges, particularly here in the Greater Toronto area, found that working remotely was much preferable to living with an hour long, or in some cases an hour and a half long commute twice a day. And they didn't have to spend time on trains, subways, or buses, or packed highways for that matter. I'll be interested to see whether the pandemic changes the way lawyers in courts practice. I'd be interested to know whether your court and personal practices will change. I know that here in Toronto, some businesses, some law firms, and some public sector employers are facing pushback from their employees about returning to work, at least on a full-time basis. Many are contemplating some kind of continuing hybrid arrangement. So that's a whole background. Let me talk to you briefly about what I think law firms and lawyers can do or might do about these issues. What can law firms do? I think law firms can begin by recognizing that we do have a mental health issue in our profession. I know that some are already doing that, making mental health and wellness a priority in their firms, creating a firm culture that destigmatizes mental illness and encourages people to talk openly about it. And frankly, I think they're doing it, at least in part, not because it's the right thing to do, but it's good business practice to do it. Keeping your employees healthy and keeping yourself healthy for whatever the reason is good for business. I think a good starting point in law firms, and again, some are doing it, it would be to create a mental health and wellness committee and to put someone respected at a high level in the firm in charge of that committee. Someone who can ensure that things get done. The committee would help continue to educate and train lawyers and staff to recognize the symptoms and the signs of mental illness, ensure that appropriate resources are available in the firm or externally to support lawyers and staff who need help, and to ensure that people who need help get help. And for some firms I know are providing direct financial assistance to their lawyers to enable them to do so, and others subscribe to programs or resources that supplement or are different from the resources available through law societies. Second, I think because overwork is a serious issue contributing towards anxiety and stress, a firm and their committee might look into ways of ensuring a system of fair allocation of work to partners and associates to ensure that some are not overworked and that some are not underworked. Being underworked can be as depressing and lead to as much anxiety as being overworked. I know that at least one major firm has established a system, a digital system to monitor hours of work and the types of work matters people are working on to ensure that they're getting enough work at an appropriate level. Third, I think, and this goes hand in hand with that, I think all firms should, if they don't already have one, should have an appropriate mentoring system to ensure that particularly junior lawyers are getting appropriate supervision and training and more important, emotional support, and the kind of support that can only come through a wiser, more experienced, and generally more senior colleague. Fourth, I think that Firms should not assume that every new lawyer who walks through the door knows how to practice law in an efficient and effective way. I think law firms should be proactive about teaching associates about issues like time management, communication, client relationships. I think some of the stresses newer lawyers experience are simply due to bad work habits. Sorry, I just want to check my time here. Finally, I think firms need to respect the need for all employees to recharge their batteries and to spend time with families and friends, unless, of course, there's a real emergency. People are talking about techniques such as having a no email policy after 6 p.m., no phone calls, no work-related phone calls after 6 p.m., and maybe even no emails and phone calls on the weekends, except for emergencies. And the same goes for vacations. Why can't an employee or a partner, for that matter, have a really meaningful no contact vacation in the summer and at other holiday periods? When I first became a lawyer, the very first day, one of the senior partners sat down with me and said, "George, you got to plan your holiday in the summer. We all take 4 weeks in the summer. It's sacrosanct. You got to plan it now, otherwise you won't take it." And people went away on canoe trips. They went away to Europe. They didn't have, well, they didn't have to worry about emails, but it can be done. Life goes on. And I think law firms have to start thinking about that and thinking about giving people a way to have a real break, not just in the big times, but in the little times that are so important. You know, hockey games with the kids, time with family at supper, quality time in the evenings and on the weekends. I'm just going to give you a reference point. I'm not going to speak about it, but there's a document out there on the internet called the Mindful Business Charter. The Mindful Business Charter. It was developed by Barclays Bank in England and some of its law firms, and a number of law firms here in Canada have signed on to it. It doesn't cover exactly what I've been talking about, and it doesn't focus on mental health per se, but it talks about ways in which law firms can practice in a mindful way that's respectful of the health of their employees and their staff, and I commend it to you. So let me just turn to my last point. What can we, you and I, and others like it, do to address some of the challenges that we all face? I just want to tell you a brief story. About 30 years ago, I was a partner in a major law firm here in Toronto. And for over 2 years, I got up dreading going to the office. It's not that I didn't like my practice. I loved my practice. It's not that I didn't like my clients. I really liked my clients. But what I really didn't like was the work environment. I just wasn't suited to a big firm. And I felt that in a big firm, for me, I'm not criticizing big firms, but for me, it wasn't the right place to be. And I felt that, maybe this goes to my nature of wanting to be in control, but I felt that other people were controlling my life. I wasn't. And so after a lot of thought and a lot of conversations with my wife, I developed a mantra. The mantra was, take control of your life, or other people will take control of it for you. Take control of your life, or other people will take control of it for you. And I ultimately, not long after these discussions, decided to leave and start my own firm, which I did. And as my wife said, I was never happier and never more productive, never more fulfilled. And it led me to suggest that we all, from time to time, need to take that look and ask ourselves whether our control of our own lives is being taken over by other people or by other things. Do we feel in control of our lives? Do I feel in control of my life? Am I living the life I deserve to live? Am I living the life I thought I would live? Do I feel like an imposter in my work? Am I happy? Am I fulfilled? Am I anxious? Am I depressed? Is my consumption of alcohol helping me get through life? Am I enjoying it, or is it taking over my life? Do I need to have a conversation with someone who will help me? Is there someone in my own family, a child, a spouse, a colleague, a friend, who may be feeling that way? Should I have a conversation with them? I don't want to suggest in any way that mental health or mental illness can be overcome without appropriate medical diagnosis or intervention. Quite the contrary. Mental health resources are available, and we know where to find it. For you, if you go to your website, it's only 3 clicks away. But I do suggest that we have the ability to control some of the stressors that may contribute to the way we feel. We do have the capability to control the environment in which we work, or to get out of the environment if it's not healthy, or to change the environment if it's not making us happy. So I'm sorry I can't be with you. It's a privilege to have spent some virtual time with you. My wife and I have made several visits to your lovely province. We have at least one on our short bucket list, something we plan to start enjoying in the very near future. In the meantime, thank you, and I'd be very happy to discuss questions or comments. Thanks, Christian.
And thank you very much. A lot of great things to talk about there. Before maybe I have any remarks, I just open it up to the group to see if there are any comments or questions relating to what we just heard.
Thank you.
Christian?
Yeah, Scott.
I just want to say thank you to Justice Drafty for this. It's very informative. I just have a couple of comments because you talked about the fact that the hourly rate billing is something that needs to be revisited. And I've been at this 26 years now, and I think for 20 of those we've been talking about that, and it doesn't seem like that is going to ever really change. It's been something that's been picked apart and talked about for ages, and it still continues to be the main source of revenue for law firms. Now, I don't work in a big law firm anymore. I'm general counsel at the university, but I'm also, so I do legal work, but I'm also a client. And so, I'd love to have alternatives to hourly billing, but it doesn't seem that that's going to take off. A couple of other comments that I've noticed over the last 25, 26 years is that litigation has become more complex. Internet resources are making people research excessively. For you used to go to the law library and pick up a few cases for your argument, and now people are researching until the cows come home, and they're finding the most obscure stuff out there and just peppering you with cases, and then also the extensive witnesses people having witness lists as long as your arm and needing an expert for everything. I've had conversation with judges early in my career where, the things were starting to go that way, and judges would look at us in the court, in the maybe the settlement conference or the pretrial conference, say, listen, when I was your people's age, I used to have a trial like this and we do it in a day. And now you're talking about scheduling 2 weeks or 3 weeks of court time. So I think litigation itself is becoming more complex, mostly because of the way that things are going in the world. But it does cause you more anxiety and more stress when you do litigation. And then, of course, there's the whole issue of constant connectivity and all of that kind of stuff. So I think those are some real issues, I think, facing the profession. And I think internet connectivity and the advent and rise of the internet has actually sometimes only made things worse for us. Yes, it makes things better because we have conveniences that arise from it, but certainly in terms of litigation, it makes things worse. And then the other thing I was going to say was court resources and time crunches. Court resources, we have long lags and long wait times for court times. And then when you do get there, I've had a couple of things set down now. We needed 2 weeks for something, and this has been March 2022, and the earliest time they could give us was September 2023. So that's a year and a half waiting for a court date, on something that's just that needs attention. So I don't know, I'm throwing up more questions and problems than there are answers, but I think these are some of the things that, I've noticed over the last number of years that have made things more stressful in this profession. Sorry for taking a long time, Christian.
No, I'd just like to make a few comments. And Scott, this won't be my last word on the topic, so I'll probably be incorporating some of the points you've made in my next version. But let me say two things. One is on the subject of value of billing. If anyone's in a position to alter law firms' behavior, it's the clients like you and the university who are in a position to say, forget the hourly. We're not going to get into the mathematics. What was your work worth? And where's some assessment of the value of the work? And I know some law firms are looking at block billing, and clients are insisting on block billing or fixed rates for specific work. Anyway, I'll leave that alone. But I think at some point clients are going to catch on and say, what is this? If I want my house painted, generally speaking, I ask for a price from the painter. Why should I be telling a law firm that I'll pay their bill whatever their hours may be? That's point one. Point two, I was there for almost 50 years ago now, where you went to the law library, you pulled out a hard copy of a book, you took it to the courtroom, you showed it to the judge, and that was the case you relied on. And I honestly never found, on another subject, I never found that a case was improved by calling yet another witness. It usually exposed you to more risk than was necessary. So I don't disagree with anything you said about the complexity of trials or the challenges of courts, but I think those are things that to some extent we need to have a hard look at and say, is all that research really leading to better value? Anyway, those are my thoughts.
And thank you. And thanks for sharing, Scott. The more these things are talked about, again, it's issues that we're all facing, and sometimes they're discussed in a group and sometimes they're not. And that's kind of the purpose of this here this morning. So I'd certainly encourage anybody else with any issues or impressions to take the time to speak up while we're here. Yeah, Brenda.
Okay. Thank you, Chief Justice Strathy, for your very insightful and timely comments on the issue of mental wellness or lack of mental wellness in the legal profession. I want to make a comment on the issue of the billable hour model and the impact that has on the legal profession generally. And I speak, from experience myself. I spent 20 years in private practice. I think that the the concern with respect to billable hours, from my perspective, goes beyond the issue of overwork. It goes to the way we value ourselves as people, because I can say that as an individual practicing law, I felt that I had more skills in my toolbox than simply the ability to practice law and deliver billable hours. But you get locked into that model and you become dedicated to, I guess, an expectation or a desire to move forward along the partnership track and other places. And ultimately you start feeling as if the only value that you have is the billable hours that you churn out, and that changes on a monthly basis. So I think that's something that law firms need to be conscious of as well. It isn't the evil associated with the billable hour, and I don't think I exaggerate too much by calling it evil, isn't just the overwork. It's the way that it devalues the individual when the only measure of your skill or your talent or your value to the world seems to be what you can do in terms of number of hours delivered.
It's a really good point. That I know it's been pointed out that the billable hour doesn't really give any acknowledgement of the efficiency, creativity, practicality, experience of a good lawyer. A good lawyer with lots of experience, who's efficient and practical and innovative, can develop a solution for the client's problems that's worth way more than the billable hours spent on it. And the flip side is true. Put an inefficient partner to work on a file, or an inefficient junior, and the billings go up, but nothing of particular value gets done. So I'm certainly with you on those comments, and I think the impact on the lawyer is a very important thing that I frankly hadn't thought about. So I appreciate that.
Thanks, Brenda. Anybody else? Suzanne?
Thanks, Christine. And sorry, my internet is not being great, so forgive me for the screen turned off. Thank you very much, Chief Justice Stratty. I just wanted to add that I work in the public sector, and a number of individuals here attending today are colleagues of mine with the province. And I just want to add that a lot of the issues that you've raised are certainly not unique to private practice. We certainly are very blessed, I think, not to have the pressures of the billable hour, but a lot of the stressors are still with us. I think it just goes to volume of work and resourcing. It's similar sort of themes, but I just want to add that we very much appreciate your comments, and I think you mentioned that you might be doing a second iteration of your paper, but just to note that these stresses exist across the board, and certainly we appreciate your comments, and I think a lot of value we'll take back to our department for to think about.
Suzanne, thank you for that. I might mention that I know that what you're talking about, and I know it's accurate here in Ontario. In fact, I drew a great deal of inspiration from some very helpful and brave lawyers in the Ministry of the Attorney General here in Ontario, who have not only spoken publicly about their own mental health challenges, but have also established a group called the Voices of Mental Health. I think if you look for it, you'll be able to find it. If you can't find it, let me know if you'd like to get in touch with them. But they have spoken openly and very clearly within the ministry, and are actually in the vanguard of the legal profession in working to bring about change in the way lawyers work and a way mental health is addressed.
Thanks, Suzanne. Gladys?
Yes, thanks. One of the things that I was going to say is, when we talk about what can we as a profession do on this issue, and I think one of the biggest things is talking about it. I mean, I've been practicing for 31 years, and this is the first seminar, and this has been an amazing seminar. Thank you. And I think that encouraging the profession to speak up and to talk about it, whether it be that you're down in court and you're waiting for your matter to be called, and there's nothing better than, they say misery loves company, but there's nothing better than talking to another fellow colleague and knowing that, what, I'm having a bad day. And when you hear that they're having a bad day and they're totally stressed, and whether it be by the court deadlines or whatever, I practice family law. So speaking to other family law lawyers about the stress of the nature of the law that we do, it actually helps. But for years, we as members have been afraid to talk about it, because if you talk about it, it's seen that you are weak, that you're not strong, that there's something wrong with you. So I think one of the biggest things that we can do, we're a small bar here in the province, but I think that by encouraging members to speak out, having more seminars like this to make us realize, what, we're all normal, we're all in this together, and it should be okay to speak to the profession and fellow colleagues about things that we're struggling with. Some weeks are better than others, some months are better, some years are better. But I think that we need to feel comfortable talking to our members about it, so that we all know that we can relate 100% and that it's okay to talk about it.
I completely agree with those observations. I'll tell you, one of the most poignant comments I've heard in the last several years. I was talking to someone at the at an organization responsible for mental health, and they had held a seminar for lawyers on mental health. And one of the lawyers who participated decided that at the end of the day, he would have a conversation with his family about mental health, and got the whole family together, his spouse and children in their late teens, and had a discussion around the dinner table. He talked about the seminar he'd been at, and they talked about mental health and how he was feeling. And as a result of that discussion, in the course of that discussion, one of his children, a daughter, disclosed that she had been suffering from serious mental health challenges, and actually had been in the process of writing a suicide note. And so people are in pain. They're in pain in our profession. They're in pain in our families, and there's help. There is significant advances since the 1961 was when I first heard the word manic depression, and there have been significant advances in both in psychiatry and in medical treatment of mental illness since those days, thankfully, and to some extent the stigma has been removed from mental illness.
Thank you, Gladys, for your comments. And I would note that the resources that were referenced, I've placed those in the chat, and I note that Don Anthony has linked another resource there as well. So please feel free to click those and bookmark them before later viewing on your own time. And we're up on the wall here now, so it's 11 o'clock. So I just want to take a moment to thank you, former Chief Justice Strathy, for spending time with us this morning and sharing your experience and insight. It's trite to say that yours is a very significant voice brought to bear on this important issue, and your advocacy is commendable, particularly now, a mere 2 weeks after your retirement, and speaking here, which necessitated somewhat of an early rise, at least by my standards, although you noted you're an early riser. But myself, since being called to the bar, I've witnessed a significant change in the profession's approach to mental health. And in my personal opinion, I think the change is really gaining momentum. I'd say that this is not a time to become complacent. As you've noted, we're on the verge, I hope, knock on wood, that we're emerging from a pandemic, but it's been an exceptionally challenging couple of years for all of us, compounded with, the documented challenges facing the legal profession with respect to mental health. We must realize that continued vigilance and advocacy is required. So you've identified a number of issues that are contributing to mental health challenges in the profession, which we've heard about in the past. What I really like in your presentation were the tangible, concrete steps that lawyers and firms and organizations can take to address that. So I guess what I would encourage our attendees to do is to take the time to reflect on your own relationship with work and its impact on your mental health. I think I can speak on behalf of the Law Society and say that we intend to continue our advocacy in this area. So if there's something that you think that we as regulator can do to better promote mental wellness in the profession, I'd certainly encourage any of you to reach out to any of us and connect. It's a conversation that we're always willing to have. So thank you again for spending time with us this morning. Thank you everybody for attending. It's a great turnout, which is a mark of the importance of this issue for all of us. So I'll leave you with that, and we look forward to welcoming you to the province in the hopefully near future.
Thanks very much, Christian. Goodbye, everyone. Bye-bye.